Hello and welcome to Coin Lady channel. Do we know the most recent information that will affect the trial's outcome? In what way, if any, will this impact the outcome in court? After these happenings, how much more will it cost? Put your responses down below. In any case, we're starting out right now. In regards to the summary judgment application, Dayton claims he does not expect Judge Torres to take a long time making a decision. An attorney for Ripple, John E. Dayton, has stated his firm is confident in its case against the U.S. Securities and Exchange Commission. In response to a tweeter's inquiry about the timeline for the judge's summary judgment ruling, the court today released its ruling on Doorbit petitions. The inventor of crypto law, who acts as an amicus curiae for thousands of Archer investors, has made this fact public. Dayton was skeptical that there would be significant delays. A judge's ruling could come as soon as tonight or it could take a few weeks, the lawyer said. Today's reporting indicates that XRP holders won a major victory when Judge Torres partially granted and partially denied applications from both sides to strike out expert evidence in her Doorbit motion. The SEC had relied on the aforementioned expert views to argue that XRP holders acquired the token with reasonable expectations of gains solely from Ripple's efforts. Last week, the attorney said it could be another 2 months before a decision is made on whether or not XRP is a security. And so, please, do not leave. Ripple's general counsel, Stuart Alderoty, recently emphasized that any one of 3 outcomes is possible here. A judge hearing this case could side with either seek Ripple or defend itself. Dayton has stated that he is rooting for this case to succeed so that the court can rule on the legality of secondary market transactions of Extropy, which the SEC claims are illegal because they constitute unregistered securities offerings. If Ripple were to lose in the district court, the winners would still be the owners of the excerpts. Scott Chamberlain, co-founder of Evernote X and Ripple, thinks the recent verdict was bad for both the SEC and XRP communities and hopes the judge will rule against the SEC's position on this case. Following a ruling by Judge Julissa Torres, in which she granted and denied various requests made by both sides, Chamberlain made the above comments. Both Ripple and the SEC community would benefit from hearing from an expert witness to corroborate their claims and provide further evidence for the efficacy of XRP. Some of the XRP community's requests were granted by the judge, but others were not. It would appear that the ruling benefited neither party. The decision stood out because it excluded Patrick Doody, a keen expert witness. The SEC's lawyers sought to have Judge Torres rule that the experts disqualified themselves as a result of the Doorbit issues, so they hired them to investigate investor sentiment. Community attorney John E. Dayton was disqualified from the case after he disclosed the identity of the SEC's expert witness. Although the judge did not rule in Dayton's favor, he did agree with his position that Doody should not be called to testify on behalf of XRP holders. An attorney for the Extropy community, Jeremy Hogan, echoed these sentiments, saying that the SEC must prove that investors had a reasonable expectation of profits from Ripple's efforts. Hogan contends that the expert theory's opinion regarding Ripple's incentives and actions to influence the XRP price is pertinent to the issue of reasonable expectation of profits, despite the judge siding with SECH on the issue of expert witness number 3, which Ripple had argued was irrelevant and unreasonably prejudicial. He says, but that's weak sauce, implying that it won't be of much help in the case. Judge Julissa Torres' possible rejection of the SEC's objections to Ripple's expert testimony on the non-securities status of XRP yesterday prompted some speculation about whether or not Ripple officials were careless in not knowing that XRP was a security, and he suggested that the testimony of Ripple's experts provided some insight into this issue. The SEC must prove beyond a reasonable doubt that the executives aided and abetted the sale of unregistered securities in order to convict them. The agency's refusal to recognize XRP as a non-security, as previously mentioned by the attorney, has bound the agency with an undue burden, the attorney said. Regardless of the SEC's public declarations and other government agencies' repeated acknowledgement of this fact. In Dayton's view, the regulator may have acted this way to either force a settlement or to diminish Ripple's position in the developing market. But it looks like the regulator will be on the losing end of this argument. In his opinions, due to rising hopes among investors that the Ripple versus SEC litigation will soon be settled, the price of XRP soared today. This suggests that the legal impasse from which we have recently emerged may soon be broken. The most crucial point to remember is that Ripple appears to be gaining ground in the lawsuit with each passing day. In the coming weeks, Ripple and the SEC of the United States may reach a resolution to their long-running dispute. U.S. District Judge Annalisa Torres' decision, which came after much waiting for a ruling on the parties' applications to exclude expert evidence from the pending action, has led to this optimistic assessment. When the decision was revealed on Twitter, the XRP Army responded with cheers and applause. A devoted XRP user known only by their online handle, Lyric, made the perceptive observation that Ripple narrowly won if one were to rely only on mathematical calculations. Johnny Dayton, who tweeted about the judgment's specifics to his nearly 246,000 followers, has been convicted of a felony. Dayton, who he says owns Extropy in response to his message, founded the legal news source Crypto Law and represents clients who are crypto asset holders. An optimistic Twitter user wondered if the recent development might shed some light on how much longer we have to wait for the summary decision. Here is an observation that Dayton made: whether it's today or a few weeks from now, I highly doubt that there will be a significant delay from here. In December 2020, the SEC filed a complaint against Ripple, alleging that the company had illegally marketed $1.3 billion worth of unregistered securities in the form of XRP coin. The San Francisco-based blockchain payment startup has strongly refuted the claim, arguing that the quoted passage does not meet the criteria of an investment contract under the well-known Howey test. Ripple appears to be in a stronger position after a string of favorable court rulings. But if the SEC side wins, it will set a very bad precedent for the entire cryptocurrency industry. Because of this potential impact, the case has been closely monitored for the past 2 years by financiers, developers, and stockholders. Attorney Fred Rispoli shares Dayton's opinion. Rispoli claimed that the most recent ruling by Judge Torres proved the importance of a summary judgment. He thinks the verdict could be handed down as soon as this month. So, either summary judgment will be issued at any time, or Jay Torres will drop this one first to entice the parties into settlement, as Rispoli put it. It's all over today. Please like and subscribe my channel. See you later, bye.